Hi, everyone. My name is Mariel Shutina, and I'm an attorney at Maryland Legal Aid. This is a Know Your Rights During COVID presentation. Just so you know, again, like I said, I'm a staff attorney at Maryland Legal Aid. I work in our community lawyering division. If you would like to contact me, or if after this presentation you have any legal questions, please feel free to either email at lawyer@mdlab.org or give us a call at 443-451-2805. This is the information from my direct unit, and one of our paralegals would give you a call back and then be in touch. So in general, what is Maryland Legal Aid? What are we here for? How can we help? Legal Aid is a private nonprofit law firm. We are quite large. We are the third largest law firm in the state, and we provide civil legal services to low income and other vulnerable people in need across Maryland. We have offices throughout the entire state. We have 12 offices. We have our largest office in Baltimore City, which is where I work from. We have all different counties, different areas, so that we can reach as many people as possible. At Legal Aid, our services are completely free if you're financially eligible or meet some other criteria. I want to talk about that a little bit more. But if you have any legal questions, you're not sure if you're eligible financially or anything like that, please again give us a call at the number or email address I gave you before, because even brief advice or a quick intake or referral is free. There's not going to be any cost for that. So always give us a call just in case. In general, at Legal Aid, we do civil legal services, so no criminal law, but pretty much everything else. So consumer rights issues, elder rights, employment law issues, family, this could be child support, custody, divorce, things like that, child support modifications, domestic violence. We have a farm workers' rights group, government benefits. This could be anything from food stamps to disability to unemployment. We do a lot of that, especially right now. Healthcare issues, housing. This could be if you're a renter, so something like rent escrow or getting your security deposit back or fighting an eviction. We also do work with homeowners, things like foreclosures is a big one. Veterans benefits is something we work on, criminal record expungement, and then we have a special unit for children in need of assistance, so children that need an attorney outside of their normal guardians for whatever reason. So how to get help, if you have an issue relating to any of those things or anything I'm about to talk about in this presentation, or you're not quite sure if it's a legal issue or not, always feel free to call us or email. Again, you can email at lawyer@mdlab.org or give a call over at 443-451-2805. This is the direct information for my unit at Legal Aid, the Community Lawyering Initiative, and someone will be able to give you a call back pretty quickly. And so what happens is when someone calls you back, it's usually one of our paralegals. They're absolutely amazing. And they would contact you to do some intake information. And like I said, legal aid services are completely free if you're financially eligible or you have some other reason that you're eligible for our services. So these questions can get a little personal to kind of find out, but everything's confidential. It does not go anywhere except into our internal system. And we're a private law firm, so it's not being released to anyone. So it would be some questions about brief biographical information, your income and assets, family information, and then just a few quick questions to identify what the legal issue is so we can link you up with the best attorney. And then once all that information's in there and everything's set and you're eligible for our services, someone will contact you for further support, be one of our attorneys. It would either be me or one of the other attorneys in my unit. And this support that we offer could be anything from brief advice on your issue. You just need to run something by us. It could be anything from drafting a letter or demand on your behalf or helping you draft documents that you could file on your own. And then in other cases, we do full representation depending on what your needs are and what the situation is. So a quick disclaimer, the information in this presentation, besides the stuff about how legal aid works, is going to be current as of February 10th, 2021. Normally, I don't need to do this kind of disclaimer, but as of right now, with the pandemic and everything else going on, local laws and rules are changing regularly. Federal laws are changing regularly. State, all of this stuff is, pretty much in flux right now. So anything in this, please double check if you're listening to this presentation a couple weeks from February 10th and you're not quite sure if what I said in here is still current, please feel free to give us a call again at 443-451-2805 or email over. We'd be happy to answer any of those questions for you. So a little roadmap for what we're going to talk about today. I'm going to do an update on the courts, then talk about tenants' rights, family law issues during COVID, emergency sick leave, unemployment insurance, stimulus checks, fraud. There's a lot of fraud going on right now, unfortunately, and scams related with the pandemic. And then I'll talk about criminal record expungement and then provide a little bit more information generally. So the courts reopening. The reason I'm talking about this is due to the pandemic, courts closed down to the public, and then they had a 5-phase reopening plan. And so what happens is, phase 5 is going to be just a regular opening basically, and then 1 is when they're shut down to the public. So it depends. So really, if you need to go to court or you need to get some files or you need anything from the court system, definitely call over and call the clerk's office to find out. Even, it differs from county to county, district court versus circuit court. So you're probably going to hear me say this a lot in this presentation. Always call over to the court before going over. But in general, we're in these different phases right now. So generally, it doesn't matter the phase you're in. This kind of applies anywhere you're going right now due to the pandemic. Any person entering the court is subject to COVID-19 screening questions, a non-contact temperature check if they have that available. You are definitely required to wear a face mask or some coverings and maintain social distancing as much as possible. And like a lot of other places, you are required to leave if you refuse to comply or you're unable to for some reason. If for some reason you can't comply or your temperature is too high so you can't come in, obviously a safety concern, there should be assistance. You can call the clerk to have something rescheduled or have something worked out. But again, always call over the clerk's office, the court, and then just to get the most up-to-date information and what their procedure is. So as of right now, as of February 10th, 2021, we are in phase 2. So what that means is the Court of Appeals and the Court of Special Appeals are fully operational. But most of us aren't dealing with that. Most of the time, if you're dealing with the courts, unless you've appealed, an existing case, you're going to be in circuit or district court. And in phase 2, they have status conferences, scheduling conferences, and any matters that can be handled remotely or without testimony or both. So you could have a hearing set in, but it could be over the phone, via Zoom, something like that. Criminal, juvenile, and the children in need of assistance matters that don't require testimony or have remote testimony options available, those have resumed in this phase. Then landlord-tenant issues. So things like emergency breach of lease involving threats or injury to people or property, and emergency wrongful detainers are being heard. So basically, a rule of thumb is in phase 2, a lot of things are being heard only if it's an emergency, something needs to happen right away, or it can be done remotely. They don't want people coming in for non-emergencies and exposing court staff and yourselves and the public to any risk. Problem-solving courts have resumed to an extent, so something like drug court. And hearings are happening remotely and on site. A lot of remote hearings are happening and they're encouraged. Even if you have a hearing date set in during this time and it's supposed to be in person, sometimes you can request remote if possible, depending on the situation. And as of right now, the clerk's offices, which are typically open to the public, are closed. So if you need something from them, you can either make an appointment or call over and do it that way. They're using mail, there's drop boxes. But right now, it's not normal operating procedure where you could just go in and go talk to the clerk. So again, if you have any questions about that, definitely call over to the particular court's office. And if not, you can always call over to us and we can try to help you kind of navigate that. So next, I'm going to talk about tenants' rights. This is a really big issue right now. There's a lot of housing instability. A lot of people are struggling to pay rent, maintain their housing because of the pandemic. So, as of right now, landlords can file for evictions, but just because someone files to evict you does not mean you have to leave. So, a landlord can't just evict you themselves, it has to go to court. And this is pandemic or no pandemic, you cannot be evicted without a court order and then a sheriff, enacting that court order basically. So just because someone says they're going to evict you or puts a note on your door saying you're being evicted, without that court order, it's not legal and it's not allowed. When it comes to evictions, you might have legal defenses, and I'll talk about that on the next slide. And that being said, even if you go to court and your landlord wins and they win the right to evict you, they can't just kick you out. They have to obtain something called a warrant of restitution, and then they have to ask the sheriff to actually conduct that eviction. So you're still given a little bit of time to get your stuff and get, another plan in place if you are evicted at the end of the court hearing. So with COVID-19, there are some developments and some defenses that you can use as of right now in order to avoid an eviction. So, as of right now, the governor's orders, there's this affirmative defense about being affected by COVID-19, and that's enacted until the state of emergency is over, which we don't know when that will be. The CDC order is putting basically an eviction moratorium for failure to pay rent until March 31st of this year. That may or may not be extended, we don't know. But as of right now, as of February 10th, 2021, until March 31st, there's these affirmative defenses that are allowed, these COVID defenses. So no warrants of restitution if you can show you lost income during COVID. So even if you're evicted, they can't come kick you out because no warrant of restitution can be granted until, if you can show loss of income during COVID. You have to present this evidence in court. You have to file a declaration and send a copy to the landlord for each person, on the lease or living there. This does not apply if a landlord lives in the same house as you. So if you're just renting a room and the landlord lives there as well, not going to be the same. And it doesn't apply if you're being evicted for any other reason. This is for failure to pay rent, and it has to be because you lost income during COVID. There could be other reasons they're trying to evict you, and that may be allowed. It depends on the court and their interpretation. That being said, all of this rent is still due and owing. So, even if you're not paying it or even if you're evicted, that back rent is still due and it still needs to be repaid, or, your landlord could take you to court for that. And you can just see down there's two links for the governor's order and the CDC order about halting these evictions due to failure to pay rent. You can also just Google it. Maryland governor's order on eviction. Might be a little easier than these very long URLs. So what does this mean? Just in general. So there's little or no protection if the eviction right now is for a breach of lease, danger to other resident, a tenant holding over, wrongful detainer, anything like that. Again, these moratoriums are only about a failure to pay rent. So if there's some other issue going on, you may be able to be evicted. If you can pay your rent or you have any income coming in, it's important to try to. It's also really important that if an eviction proceeding is set in court, there's a hearing, please go. You want to bring any and all documentation you have. And, if you have questions or concerns or potentially need representation, definitely call us. We do have something called at Legal Aid called Lunch and Learn, and we stream it on our Facebook Live, and we have done some great videos explaining these different things. So if you use Facebook, definitely check out our website and go to the live videos. And there's a couple different videos in that series about evictions and issues around evictions and housing issues during COVID. So another thing there is paying utilities. So in addition to your rent, a lot of people are still paying utilities, and that's been pretty hard to keep up with. So during the pandemic, during the emergency in Maryland, these companies cannot charge you a late fee. So if you back owe stuff, normally they would tack on some late fees, and that's not happening right now. And they're not supposed to be turning off your electricity or something during this pandemic either. It's always a good idea to try to set up a payment plan with your utility company if you've been struggling to pay, because again, that money's still owed. So some of them have 12-month or 24-month payment plans, things like that. But please be aware, and I'll talk more about fraud issues, but be aware of fraud with people kind of saying that they can lower your utility payments or helping you negotiate a payment plan unless they're coming from, your utility provider on their own. So one of the next things I'm going to talk about is family law. So custody, visitation, and child support. We get a lot of questions about this. It has been kind of hard to maybe comply with your custody orders if, one parent's supposed to have the child 2 days a week, but it's been hard to travel or someone's been exposed or things like that. It could get a little tricky during COVID. The issue is, though, that all court orders still apply during the pandemic. So if an order permits and both the parents agree, you can adjust your custody time, what makes sense. And if everyone's in agreement to it, you don't really need to do much. You can just kind of do that on your own, and that's okay because everyone gets through a pandemic. But if both parents can't agree and you can't come to some agreement or compromise on what should be done during the pandemic, then both parties must follow the order. It's still a court order, and it needs to be complied with. The big thing I'm always going to stress when it comes to custody and visitation, especially when children are involved, is to just try to use common sense and be courteous and kind of what makes sense in this situation that no one anticipated, and we're not quite sure how to navigate it just yet. But if there's no agreement between the parties, the court order applies and needs to be followed. The same with child support. There's no changes, there's no exceptions here. Child support is still due and owing as well during the pandemic. Right, so another big issue that we're seeing a lot of is emergency paid sick leave. So under the CARES Act, which came about due to the pandemic to kind of address some of these issues, expanded emergency sick leave is only available until December 2020. And then employers can get a tax credit if they decide to extend it to March, but it was up until to your employer. So if your employer extended this, and this may change, federal laws are changing all the time with the pandemic, but as of right now, like I said, as of right now, this is what the law is. So who is eligible for this emergency paid sick leave? Full-time and part-time employees, anyone working for a private sector employee, as long as they have less than 500 employees. And then employers with less than 50 employees might be exempt, but they need to get an exemption from the Department of Labor for this. So basically, almost all employers are subject to this. And then if you work for an incredibly large place that has over 500 employees, they are exempted for some reasons as well. If you have a particular question about that or have an issue, please reach out to us for individual assistance. But for emergency paid sick leave, it has to be COVID related, and I'm going to talk about what those reasons could be on the next slide. And unfortunately, this is not applicable to contractors or gig workers. Basically, it's for W-2 employees, unfortunately. So emergency paid sick leave, the COVID reasons could be any of these I'm about to talk about. So being subject to a government quarantine or isolation order related to COVID-19, if you've been ordered to quarantine and can't go to work, you'd be eligible for this emergency paid sick leave. If you have been advised by a healthcare provider to self-quarantine due to COVID-19 related concerns, again, that makes you eligible. If you're experiencing symptoms and you need medical diagnosis or have a diagnosis, you shouldn't be going into work, please, if you're sick or having COVID symptoms. So that's another reason this emergency paid sick leave is there. If you need to care for an individual who is subject to one of these orders from one or two, if you need to care for a son or daughter or a child whose school or place of care is closed, so daycare provider or school isn't open anymore, and a child care provider is unavailable due to COVID-19, you can use emergency paid sick leave. And then if you're experiencing any other substantially similar condition. So there is a little wiggle room on that, but it needs to be COVID related. So how does this emergency paid sick leave work? How much do you get paid for it? So if you were one of those first three reasons I gave, you receive 100% of the qualifying, so up to $511 daily or up to $5,110 total. If you were one of those reasons 4 through 6, you can get up to 2/3 of your pay or up to $200 daily and $2,000 total for the whole thing. And then up to of paid sick leave and expanded family medical leave at up to 2/3 of your rate, your hourly rate or your daily rate, whatever it might be, however that's calculated for qualifying reason number 5 for up to $200 daily and up to $12,000 total. So how long does this last? How long do you have it for? It's up to 80 hours, about 2 work weeks if you're working a 40-hour week of emergency paid sick time. Employees who have been employed for at least 30 days prior to their leave request may be eligible for up to an additional 10 weeks of emergency paid sick leave and up to 12 weeks of paid sick leave and expanded family and medical leave. And so after the first 2 weeks of that, you get paid up to 2/3, which that would be up to $200 daily or $12,000 total for the all 12 weeks. If you're not receiving emergency paid sick leave like you think you are, or you have any other issues related to this, you can always file a complaint with the US Department of Labor. There's a number there, it's 1-866-487-9243. You can also go online to DOL, just Department of Labor.gov/agencies/WHD. So another big issue that we're seeing a ton of at Legal Aid and in general is unemployment insurance. So there's a lot of different types now. They're kind of overlapping and confusing. So I'm going to go through each one. But again, if you have any unemployment insurance related issues, definitely please feel free to call us about it. We're seeing a lot of this right now. So the different types, and I'll explain all of them in the next slides, are going to be regular unemployment insurance, pandemic unemployment assistance, PUA, the Federal Pandemic Unemployment Compensation, FPUC, Pandemic Emergency Unemployment Compensation, which is PEUC. Then there's something called the Maryland Extended Benefits, which isn't currently available, unfortunately. And then something called the Mixed Earner Unemployment Compensation, or the MEUC. So what is regular unemployment? This is what people have been using for years. We had this system before the pandemic. And so traditional unemployment or regular unemployment is for people who had a W-2 job, getting salaried or paid, or not a 1099, basically a W-2 employee. You lost your job through no fault of your own, and you had a work history, so you need to complete enough work history and payments into the system. And the amount per week that you could receive in unemployment insurance is up to $430 per week. But this depends on how much money you've made in the past, what your rate was before, things like that. And the duration for regular unemployment was up to 26 weeks. If you think you fall into this category or really any of the unemployment categories I'm about to talk about, you can apply for unemployment at beacon.labor.maryland.gov. Beacon is what the system is called in Maryland, the online system. If I refer to that throughout this presentation, that is what I'm referring to. Beacon is the unemployment online system in Maryland. So pandemic unemployment assistance, the PUA, this was for people that are gig workers, seasonal workers, contractors. Basically, if you filed a 1099 instead of a W-2, you weren't normally, outside of the pandemic, eligible for unemployment. If you lost your job in one of these ways, there wasn't a lot of government assistance. But because of the pandemic, so many people that weren't eligible for regular UI, regular unemployment insurance, needed that assistance. So they enacted the Pandemic Unemployment Assistance Program. You don't need a long work history, almost little to none. And this also can be used if you cannot work or you're unable to work due to COVID or COVID-related family issues such as childcare. The amount per week is going to be the same as regular unemployment insurance. and you can receive up to 50 weeks total until April 2021. So if you apply in January, your benefits will end in April, even if you did not receive all 50 weeks though. So it kind of cuts off April 2021. Again, this may change, but as of today, this is how the law is. Then the Federal Pandemic Unemployment Compensation, FPUC. This is for people who received regular or the PUA. This is an additional $300 in addition to your regular UI or PUA benefit. And this applies from January 2nd to the week of March 13th of 2021. And you don't need to apply for this. If you've already applied for your traditional UI or the PUA and you've been approved and you're receiving payments, you should automatically be receiving this extra $300 a week. The Pandemic Emergency Unemployment Compensation, PEUC. This is for people who had applied and received their regular UI or their PUA benefits and they exhausted them. You can only receive them for so long. So if you're still not unable to work due to COVID or whatever reason, you could receive the Pandemic Emergency Unemployment Compensation. Amount per week is going to be what your regular payment was before you exhausted them. And the duration for this is, again, up to 24 weeks total until April 2021. So if it hits April 2021 and you haven't received all 24 weeks, that doesn't matter. They stop at that point. But you can receive up to 24 weeks depending on when you applied for this and when you received it. This is one where you can't just go to Beacon. This is something that Maryland Department of Labor will notify you if you're eligible for it. If you think you're eligible and you're not receiving that information, they're not notifying you, you can always reach out to us about it as well or try to contact them. So there is also something called the Maryland Extended Benefits. This isn't currently available and availability is based on Maryland unemployment rate. So depending on how many people are unemployed in the state, when is available or when it's working, it would be for people who have exhausted their UI, their PUA, and their PEUC. And again, the amount per week is going to be the same as your regular payment, and the duration is up to 13 weeks of this benefit you can receive payments for. Again, this is a situation where Maryland Department of Labor will notify you if you're eligible. If you think you are eligible and you haven't been notified, definitely reach out to them or us. And then the last type of unemployment insurance I'm going to talk about is the Mixed Earner Unemployment Compensation, MEUC. So this is for people who were receiving their regular benefits or any of those other benefits I was talking about. It is not available for the PUA, but for the other ones. And you have to have documentation that you earned at least $5,000 in self-employment in the prior taxable year. So if you were self-employed, you were a 1099 employee, your last taxable year, and you earned more than $5,000 in that capacity, you have to have that documentation though. And this allows you an extra $100 in addition to your regular benefit payments. And the duration of this is from January 2nd, 2021 to March 13th, 2021. This may or may not be expanded, but as of right now, it's only good through March 13th. In Maryland, we're not available to apply for this yet, but Department of Labor will inform eligible claimants once it is available, and this can be backdated. So for unemployment insurance, Maryland Department of Labor has not opened applications for these new pandemic benefits as they're still waiting on this federal guidance about it. So like I said, claimants would be notified once they can apply for the extended benefits. Applications must be submitted by March 13th, and contact us if you have applied for this and are denied. So stimulus checks is another big issue that we're seeing a lot of for good reason. So for stimulus checks, eligible payments were for adults with a social security number, and this could be a citizen with a social security number or a permanent resident, a green card holder, anyone who has a social security number. If you filed a tax return in 2018 or 2019, you could receive the automatic payment. And if you filed jointly with a spouse that has a social security number also, you receive that automatic payment. If you are on SSI, Social Security Disability, or railroad retirement, this was another automatic payment. If you did not file taxes, but you entered a non-filer payment info at irs.gov before November 2020, you received the payment as well. That non-filer payment tool is no longer active. They may or may not reopen that, but as of right now, that was who was eligible when they were releasing those benefits, those stimulus checks before. Unfortunately, you're not eligible if you did not have a Social Security number, if you only had a tax number, a TIN, or an alien number. You're not eligible if you were claimed as a dependent on someone else's tax return, or if you're a minor child with a Social Security number, but your parents do not have a Social Security number. We see this a lot, unfortunately, not receiving the benefits for the child if the parent is not a citizen or green card holder, or doesn't have a Social Security number for whatever reason. So there's been 2 stimulus checks that have been put out already. If you were a single filer, so just an individual, if you made under $75,000 in the previous tax year, your first payment amount was for $1,200 and your second payment amount was for $600. If you were making over $75,000 a year, your payment was reduced until you hit about $100,000 and the payments would stop. But the majority of people are making under $75,000 a year as an individual, receiving $1,200 in the first stimulus check and $600 in the second. For married couples, joint filers, this amount was doubled. So under $150,000, the payment would be for $2,400, each of you receiving $1,200, and the second payment for $1,200, each of you receiving $600. And then any amount over $150,000 up to $200,000, that payment was reduced. So also in these payments, if you have a child or minor children that live in your home with you that were put as dependents on your tax return, each child you would receive $500, and then in that second payment it was $600. With these though, the child has to have a Social Security number. At least one of the parents has to have a Social Security number. The child has to have been claimed as a dependent on the last tax return, and the child had to have been under 17 and earn no significant income. So if the child was filing on their own and not being claimed as dependent or something like that, you would not receive the amount of money for them. So one of the big issues is that when people were receiving stimulus checks, the checks were being garnished. So for the first stimulus check, the state could garnish for current judgments in state court. Banks could garnish for unpaid fees. And if you owed arrears of child support, you had back owed child support due or owed, that could be garnished, unfortunately. For the second stimulus check, they stopped it, that no one could be garnishing those. So if you were entitled to receive a stimulus check, it should be coming to you. It should not have been garnished. So for those who were eligible but didn't receive the payment for whatever reason, it can be claimed by filing a 2020 tax return in 2021. So what that is the economic impact payments were an advance payment of what is now called or will be called the recovery rebate credit on the 2020 Form 1040, which is the tax form. So if you did not receive your stimulus check, but you should have, or you believe you were entitled to it, if you file taxes in 2020 or for 2020 in the next few months, you could get that money back. You do not have had to have had income to file taxes. You could have 0 as your income for that year. As long as you file, you could possibly get that recovery rebate credit. And if for any of your stimulus payments you received a debit card, do not throw it away, because they would just be adding that money onto that debit card again. So definitely keep that, because it'll be hard to get another one. So another big issue during COVID, unfortunately, which happens, pandemic or no pandemic, there's fraud, but it's been a lot of fraud related to COVID, people taking advantage of the situation. So one thing would be fake products to treat or prevent COVID-19. It could be ads on social media, asking for your Medicaid number, your Social Security number, your health insurance information, things like that. Calling, emailing, mailing, pretending to be the government, wanting to give you a check, but saying that you need to provide your date of birth and your Social Security number or your bank account number, things like that. I always like to think that the government's probably never calling you. If someone's calling you on the phone, it's most likely not the government or anyone related to it. They most likely send you something in the mail. Things like spyware and malware are getting installed more commonly now, unfortunately. Part of it is that a lot of people are at home on their phones or their laptops or their computers, things like that. There are things like ransomware, locking your computer or phone, not allowing you access to it until you pay them. And then unfortunately, a lot of price gouging. This could happen anytime, but we are seeing a lot of the rates of this increasing during COVID. So for this fraud, please don't respond to texts, emails, or calls about checks from the government. They already have your information. Usually you contacting them, they're not contacting you. And again, they're probably definitely not calling or texting you. Ignore offers for vaccinations and home test kits. Any offers where you need to put a credit card number in or enter any personal identifying information. Most of these test kits and things have not been approved by the FDA, and they aren't necessarily accurate, so you could just be wasting money, even if they're not trying to steal your information. Robocalls, definitely hang up, don't try to engage with them. They could be trying to use voice information or whatever it might be. Emails claiming to be the CDC or the World Health Organization, anything like that, anything that asks you for a link. If they're asking you to go to a website that doesn't end in gov, that's a government website. If they're asking you to go to some other website, I would be hesitant to do that. Don't click on links from sources you don't know. This one is just in general, but always do your homework when it comes to donations, and please don't be wiring money or gift cards or cash to kind of unvetted organizations or charities. Or if anyone offers, just pay me $100 now and I'll pay you back tenfold. That's not usually real, unfortunately. If you have been defrauded or had any of these things happen to you and you've lost money or personal information or things like that, always contact the Attorney General's office. They help with these issues. And their website is www.marylandattorneygeneral.gov. Again, that .gov right there is a key when it comes to government websites and contact. There's also a lot of common housing frauds going on, unfortunately. So foreclosure and mortgage scams, people advertising they can help you make your mortgage payment or be this go-between between your mortgage company or the government. Please make sure that anyone who's offering to help with this is HUD certified. HUD certified counselors are going to be your best bet, just to make sure that they're legitimate, again, not trying to take your information or your money and not help you. Another one we're seeing a lot of is rental scams. So fake ads, fake addresses, expensive background checks, anything like this. If you are looking to rent a place, check it out on a map. Google it first, see if it's a real place. Don't pay anything before seeing a place. Don't work with an agent if the owner's out of town or you can't meet the owner, things like that. Make sure that the agent is legitimate, and always insist on a written lease. This is all the time, unrelated to COVID or not. You definitely want to have any lease, really any contract in writing for your safety, things like that. And again, if you have any of these issues happen to you, always contact the Attorney General's office, which again is www.marylandattorneygeneral.gov. So one of the last things I'm going to talk about is expungements. Criminal record expungement is not COVID related, but it's still important, and it's something that I do a lot of at Legal Aid, and it affects a lot of people. So what is expungement? We're talking about criminal record expungement, and it is the removal of police and court records from public view. So in Maryland, basically anytime you step foot in a courtroom, if you were a defendant, a plaintiff, it was a civil suit, criminal, whatever it is, it's public record. It's on a website called Case Search. You just Google it, Maryland Judiciary Case Search. And what it is, it has all this information on it. It has your name, your birth date, your address, all the court history, the charges against you, the dispositions of the charges, things like that. And that is up there unless you ask the court to remove it. So obviously this can have a lot of ramifications. If you're applying for jobs, applying for housing, trying to get a professional license, applying for school, anything, people can see these records. And unless you ask for them to be expunged, they're going to be up there. So if you have anything on your record, criminal record wise, you can't expunge like a civil case, unfortunately. Your divorce most likely is not going to be able to be taken off a case search, but criminal records may be able to. So who can get expungements in general? You have to be the defendant in the case. You can't be the victim in the case or related to the defendant. You have to be the defendant in order to request an expungement. You can't have any active cases otherwise, so you can't have a pending criminal case for something else. It's just the way the law is written. They won't provide expungements on other cases if you have an active open case. Being on probation is not an active case under the law for this. So as long as the case has been disposed of, there's a disposition entered. So you were found not guilty or even guilty and put on probation. As long as that's, there's been a final decision in the case, that's not active anymore in the realm of expungement. And then if you do have an active case because you're enrolled in a specialty court, like a drug court, which is the one we see mostly, that's okay too. That doesn't really count. You shouldn't be penalized for, getting help and being a participant in a drug court. So definitely that's okay as well. And again, if you have questions or you're not sure if you're eligible or not, definitely reach out to us. So when it comes to expungements, it's all about the disposition of the case. Like I said, disposition is what was the final judgment. So that's how you decide how the court decides something can be expunged or not. If you received a favorable disposition, so something like a dismissal, you were acquitted, found not guilty, or you received a null pros. Null pros, an NP, is when the state's attorney declines to prosecute the case. So as long as you weren't convicted in another charge in that case, multiple charges and dismissed on one and guilty on another. But if all the charges in that case from that same incident are favorable, you can have it expunged right away. You can file to have it expunged right away. You do have to sign a waiver saying a general waiver and release not to sue. It's because there is a 3-year statute of limitations to bring this type of lawsuit. They don't want to destroy the records, expunge them, and then have someone bring a lawsuit and they can't defend themselves anymore. So you can either wait the full 3 years, and once you've hit 3 years from the disposition date, not the date of charge, the date the court entered that final disposition, you can have it file for expungement at the 3-year period, or if you sign that waiver and release, you can file immediately. I've seen people get a not guilty in court and walk down to the clerk's office when we were allowed to do that and hand in their expungement paperwork that same day. For STET, a STET is the state's attorney has declined to prosecute at this moment, so it's being held but could be reopened. And the state usually has 1 to 3 years. They're allowed to kind of reopen that case and prosecute for whatever reason. So in regard to stats, you have to wait the full 3 years. You can't sign a waiver and release, but once you've hit 3 years from the disposition date of receiving a stat and you didn't receive a conviction in that time, in that same charge, that same unit, that same case, basically, then you can have that expunged. And then another really common disposition we see is probation before judgment. Probation before judgment, again, has that 3-year wait. It's a hard 3-year waiting period, or until the probation is over, whichever one is longest. So if you have a probation before judgment and it was a 1-year probation, you have to wait that full 3 years. If you had a probation before judgment and the probation was 4 years, you have to wait the full 4 years. But you don't have to wait an extra 3 years on top of that. It's just whichever one's longest. So for most people, it's a 3-year wait. You cannot have a conviction. You cannot be found guilty either in that same case or in any case in that 3-year period or your probation period. If you receive a conviction in your probation period or within that 3-year period, the probation before judgment gets kind of stuck on there and isn't eligible for expungement, unfortunately. So those are the non-conviction dispositions. And then when it comes to expunging either a misdemeanor conviction or a felony conviction, it depends on what the charge was. So the legislature enacted something called the Justice Reinvestment Act. And basically, it allowed certain convictions to be eligible for expungement. And you have to wait 10 or 15 years. And it has to be one of the charges that the legislature listed out. So if it's not listed in the statute as an eligible charge, it's not eligible to be expunged, unfortunately. So if you have a misdemeanor conviction or a felony conviction, definitely reach out to us so we can look at your record and determine if it is an eligible charge. You can Google it also, look it up online, but we can do it very quickly for you. So when it comes to a conviction, a misdemeanor, if it was a guilty of probation, an Alford plea, but usually it's just a guilty. It depends on the charge. If it's one of the eligible charges, you have to wait 10 or 15 years. You cannot have a conviction during that waiting period, unfortunately. But if that's true and you meet all those criteria, you can file for expungement on them. The ones you're going to see most commonly are possession of some drug, trespassing, prostitution, theft, things like that. Those all have a 10-year waiting period. And then the only misdemeanor with a 15-year waiting period is second-degree assault. That has a 15-year waiting period for that misdemeanor. And then for felonies, most felonies are not eligible for expungement, but the legislature did add 3 of them. And if you were convicted of one of these and you have to wait a full 15 years and have no convictions during that 15-year waiting period, those felony convictions may be eligible for expungement. So burglary, degrees 1, 2, and 3. They forgot to add in 4th-degree burglary, but we still try to file those because it's clearly a mistake. Possession with intent to distribute a drug, not actual distribution charges. Those are not an eligible felony, but possession with intent. And then felony theft, so theft over a certain amount. Those are the felonies that are eligible. One of the other ones on here that isn't written down, but it's really important to know, is that possession of marijuana. So if you received a misdemeanor conviction for possession of marijuana, if it was less than 10 grams, that's immediately eligible for expungement because it's no longer a crime in Maryland. It's just a civil citation. So if you ever received a guilty on a possession of marijuana less than 10 grams, that is eligible for expungement, and that has no subsequent conviction rule. Does not matter. And the other is possession of marijuana, really any amount less than an intended to distribute amount. So any possession of marijuana charge over 10 grams basically is eligible for expungement after 4 years from the disposition date. And there is no subsequent conviction rule for that either. So that's a good one to know. That's important because a lot of people have those convictions and those are more readily able to be expunged than another misdemeanor conviction. And one more important thing to point out is when I talk about waiting periods, so the waiting periods for a step, that's 3 years from the date you receive the step. When it comes to convictions, it's 10 or 15 years from the end of the sentence date. So if you were convicted on January 1st, 2010, for something that had 10-year waiting period, but you received a 1-year sentence, your sentence wasn't over until January 1st, 2011. So you have to wait the 10 years from that. So guilty, the waiting period begins at the end of the sentence versus any other disposition where the waiting period begins the disposition date. So how do expungements work though? So if you have anything on your record, you're not sure if it's eligible or not, or you just want assistance, please contact us. Legal aid expungement assistance is completely free. If you are financially eligible, if you're not financially eligible, we'll still look at your record for you and can help you, fill out the forms. If you are financially eligible for our services, not only would we fill out the forms, explain what can and cannot be filed, what is and is not eligible, we'd also file the forms for you. And then if for some reason a hearing was needed, we would attend that for you and represent you. So what happens with expungements normally is you file the paperwork with the court. The court then notifies the state's attorney's office, the police, and in the case of a conviction that has a victim, the victim would be notified as well. But typically just the state's attorney and the police are notified, and they have 30 days to object. Most of the time no one objects, and the court will just sign off on it. You don't have to go to a hearing. But if someone does object, an objection could be, this was, this has a 3-year waiting period, but it's only been 2 years or something like that. The court holds a hearing. So if we filed expungements for you and you received a hearing notice or an objection, we would represent you at that hearing. But typically with expungements, as long as everything's in order and it's eligible, you don't have to go to a hearing. It will just be ordered and you'll receive that signed in the mail. If you don't want to use legal aid, you can always file on your own. You want to talk to the clerk's office in the court where you were charged or convicted. You always have to file the expungement paperwork with the court that the case was in originally. And you want to go to the highest court of reach. So if you had a charge in district court and then you requested that it go to circuit court, so you requested a jury trial or something, you want to file in the circuit court to have it removed, and then they'll let the district court know once they've agreed to it. You don't want to file you always want to file in the highest court. Most expungement petitions are free to file, but there are $30 filing fees if you're applying for a circuit court record or if it's for a conviction that you need to have expunged. If you use Maryland Legal Aid Services and we're able to represent you, we would have those filing fees waived. So that is it for this presentation. If you have any questions, comments, absolutely anything, always feel free to contact us at lawyer@mdlab.org or give us a call at 443-451-2805. And again, I encourage you to check out our Facebook page, www.facebook.com/Maryland Legal Aid/live-videos. These live videos cover our lunch and learn, like I talked about, but we cover different topics. So there's one on expungement that goes even more in depth than what I just said. There are sessions on unemployment, evictions, things like that. So definitely check that out if you want some more information. But if you're interested in any services from us, you have any questions, please reach out to us at lawyer@mdlab.org or again, 443-451-2805. And we're happy to help. And again, our services are free. And as of right now, we're doing everything by phone and email. So you can get services and assistance that way without having to come in and meet in person and risk anything with the pandemic. So thank you all so much. I really enjoyed talking with you, even if it's virtually and you're watching this much later. But again, just know that all of this information is up to date as of February 10th, 2021. And check with us or the courts or look it up online, because things are changing all the time. But this is the best information at the time right now. Thank you all so much, and I hope you have a great day.